Welcome, guys and gals, to A.W.A.R.E's Trust Basics webinar this evening. I thank you for coming out on this very awesome, great, beautiful, abundant, prosperous Sunday evening. I am Emilio, and I'm going to be discussing with you guys the importance of trust and a couple of different trusts and how to go about setting up your trust. Any questions that you guys may have, please save it for after the webinar. If it's not pertaining to trust, then please go ahead and ask your question in the chat, and one of our amazing team members will, answer your questions in the order it was received. So greetings, welcome to tonight's show. I'm your host Emilio with A.W.A.R.E. Are We All Really Educated.com. Tonight I'm going to be sharing basics and benefits of trust, the benefits of trust, and operating privately with your trust. Please watch this webinar all the way through before asking a question, as I mentioned a bit ago, because your question may be answered during this webinar. Okay, unless your question is not related to trust, then you can please go ahead, put your question in the chat box, and one of our awesome team members here at Team A.W.A.R.E will respond in the order which it was received. Okay. What is a trust? Well, a trust is a lawfully created entity. A trust is created by a first person of a new second entity who owns assets for the benefit of a third person regarding that property. In other meaning, a trust is a three-party fiduciary relationship in which the first party, the trustor or settlor, transfers property upon the second party for the benefit of the third party, which is the beneficiary. Now, guys, I get asked so many times during my consultations, why is it that when I'm having remedy, but then they don't want to deposit any money? They I guess the treasury, they send money to the from the treasury, and people are getting their checks into the bank accounts, and then they start receiving money from the treasury. And these are people who are having success. First and foremost, how are you going to have the treasury send you and deposit checks into your bank account when it's the ends legis bank account? You see, you haven't separated yourself, and a lot of people are operating on the public and the private. This is why it's so important to have your trust accounts properly set up and separate yourself from the public to the private. Again, people, yeah, they're having success, but then the success stops. Then they get discouraged. And why? Well, guys, you guys are not following protocol, and this is why it's very important. If you're on this live webinar tonight and you're interested on being able to set up your trust and to operate more on the private and have less repercussions come back at you because you didn't know what you were doing, then this webinar is for you. If you're not interested in trust, then you can please exit. You have yourself a beautiful, blissed evening. But if you're interested in trust and how to set up trust, then this webinar is definitely for you. If you have questions that are not pertaining to trust, then please, once again, leave it in the chat. I'm going to do my very best because I know people have to go to work tomorrow, and I'm going to speed through this as appropriately as possible and efficiently as possible. Okay. Now, a trust may be formed in two ways: a statutory trust and a common law trust. Statutory trust. A statutory trust is a privilege by the laws of the state. I don't want that one. Thank you very much. I'll pass. I don't want that one. Statutory law consists of millions of laws governed by the state statutes and codes. The statutory laws are subject to change every year and can be quite complicated that they require well-paid lawyers to keep up with them. They have created a whole industry of lawyers that parasite off of society because of it. Such laws are generally designed to benefit the few at the expense of the many. The lawyers, the politicians, the big corporations, and the cabals favored interest. Legal entities set up under statutory law are subject to those millions of laws and require expensive and complicated legal expertise to defend them. I'll pass on that. I'll take this trust right here. And most likely many of you will want to take and create these type of trusts. Common law trust. A common law trust is created by constitutional right, unregistered, and not governed by any state laws, making it a pure common law trust. The U.S. Constitution allows each state the right to grant trust and also allows each individual the right to contract in the form of a trust. Common law, by contrast, has been around for millions of years and will continue to be around for years on. It rarely changes and is simple. It's basically don't lie, don't steal, and don't violate the rights of others. It is the closest thing to natural law or universal law that is active in human affairs. It was the basis of the U.S. court system until 1938. It is still the underlying authority and is now returning in force. Trust and legal instruments that are created under natural law have far greater freedoms than statutory trust. Unlike statutory trust that may require probate, common law trusts are private and are away from the public venue. Common law trusts are subject only to the natural law and are sovereign and immune from the ever changing statutory laws. They can go on generation after generation well into the golden age and flourish because they're based on what is timeless. When the privileges to form a trust is granted by the state, the trust must abide by state laws, which is the case for statutory trust. The right to establish a pure common law trust is guaranteed by the Constitution of the United States in Article 1, Section 10. The right of unlimited contract was so named by the Supreme Court of the United States and has been upheld many times. No state shall enter into any treaty, alliance, or confederation, grant letters of marque or reprisal, coin money, emit bills of credit, make anything but gold and silver coin, a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any titles of nobility. Trust basics to know. Here are some basics to know when working with trust. Most are pretty self explanatory, and you should understand the reasoning behind each one. Trust operation. All trusts operate by the design of the trust conditions and terms in its declaration, the document of the contract. After the declaration of trust, a trust consists of a person who starts it, the creator, the trustor, or the settlor. The trustees, two or three persons who will oversee the trust. The beneficiaries receive the proceeds and assets of the trust when they are distributed by the trustees. Therefore, beneficiaries benefit from the assets placed in the trust. Trust assets. Trusts own assets entirely more like the beneficiaries own it and have complete control over their disposition, which are made pursuant to the trust declarations. At the same time, the Constitution allows each state the right to govern the creation of certain legal entities, such as sole proprietorships, corporations, and statutory trust. An example is a Delaware corporation. When formed in that state, the trust has attractive benefits not available in other states. This is one of the states that I use, including Nevada, which are, of course, as you know, with the tax exempts and all the benefits being a business owner. Those two states are my favorite: Nevada, Las Vegas, Nevada, and yes, Delaware. Keeping your trust documents private. If your trust is common law, most officers may want a copy for their records, but it's really not necessary or required to provide all officers with their own copy of the trust document. There's only one copy that is considered to be the official copy, and that one is always held by the trust officer for the first trustee. That copy, along with all future minutes that are recorded, should be always kept in a safe place. If stored electronically, always have a backup copy off site. Your common law trust is private and away from their public venue. Citus address. The citus address is one that establishes what laws and jurisdiction prevails over the establishment of the declaration of trust. You may use your own mailing location, such as a private mailbox or P.O. box. It should be an address different from your home. That way, you create that separation between you and your trust to remain more on the private side. You are always free to move the situs of the trust. Because of the way the document is written, that would re-establish the governing rules for the trust to that new location. Depending on your particular situation and desires, that could be advantageous. The mailing address is assumed to be the situs address, unless specifically changed with an appropriate minute. The mailing address does not have to be the same as the situs address. For best results, you could consider leaving the situs address as your mailing location and then draft a minute, changing the mailing address if you find it necessary. Name of trust. The name of the trust is unimportant as long as it is established as a declaration of trust. Some people like to use a name with the suffix holding trust, management trust, etc. Others prefer suffixes like foundation or group, etc. You cannot, however, make it appear as a banking or traditional financial institution. One thing to watch out for is you don't want to use the words corporation, company, partnership in the name of your trust. That would imply this is something other than a declaration of trust, which is a contractual agreement organizing to do business. The proper terminology for the identification of common law trust is a declaration of trust. It is also known as an unincorporated trust organization by contract. If it's a family trust, name it John Aware Family Trust. For an example, add your last name in the name of the family trust. Settlor, first trustee and beneficiary. There are three main parties to a trust: the settlor, first trustee, and the beneficiary or beneficiaries. The settlor and the first trustee contract amongst themselves to start the trust for the benefit of the third party, the beneficiary. The settlor is someone that is protecting the beneficiary's interest and wants to donate the initial $100 into the account of the trust. This $100 is a total gift by the settlor and is now considered principal of the trust until such time that it is paid out as income to the beneficiary or beneficiaries. The settlor decides who the beneficiaries are and how the trust is structured. But beyond that, the first trustee takes over day to day operations of the trust. The first trustee now has the right to bring on additional trustees, called secondary trustees, to help oversee the operation of the trust or to run specific aspects of it. The beneficiaries of the trust are the ultimate recipients of any and all income derived from the trust activities, so be sure how you place people in this position. The easiest structure to set up is one where you become the first trustee. A very close friend, significant other, family, or co-worker can sign on as the settlor, and your children serve best to become the beneficiaries. This is an example of how a trust is generally set up, but you by no means have to follow these guidelines. Very important that your second trustee is someone whom you trust with all your life and finances. Good luck with that. I know it took me months to find my trustees. And boy, it was not easy, but I'm thankful and grateful with the trustees that I have, because once again, it has to be someone that you trust with your life and your finances, okay? Very important, guys. Your second trustee should be on the same page as you with the trust goals and should understand the role of being a trustee. Significant others, parents, a loyal close friend, or someone else whom you trust can be your trustee. One rule to watch out for: the three parties must be separate individuals or entities. You cannot be the beneficiary of a trust in which you are the first trustee. That is a highly precarious situation, one in which you don't want to become involved. Everyone knows one or two individuals they can trust well enough to place assets in their care. The reasoning is that you want to control everything but not to own anything. Therefore, if you control the trust which owns all of the assets, you control what was the assets you used to own. What is the difference in doing that and you owning your assets and controlling them? Nothing. Except for now, you're judgment proof. No one can sue you and win something that is not yours. Ain't it beautiful, guys? That's what I'm talking about. This is why it's very important for you guys to understand, actually overstand, understand becoming private and public, and the importance of public and private. Okay, very important. One word about grantor trustee. A settlor is presumed to be giving the initial assets to the beneficiaries. If it is shown that the settlor still retains control of the assets, it will be judged that the settlor is in fact a grantor trustee. The income from the trust assets will then be taxable to the settlor, even while the assets remain in the possession of the trust. This is why we said it would be safe to choose a close friend to be the settlor. The settlor has initial desires and wishes to make a gift, but beyond that, they relinquish all control over that gift to the first trustee. Also, a settlor cannot have any financial interest in any present or future endeavor that the trust embarks upon. Be careful who you choose for the settlor position. Secondary trustees. Any secondary trustees must sign the minute pertaining to their appointment. Trust certificate unit holders. The beneficiaries are the trust certificate unit holders. Wherever you prefer to and place beneficiaries in this document, always remember to list those names with the proper number of TCUs, standing for trust certificate units, that are issued. There are always no more and no less than 100 TCUs issued at any time. It is the settlor's initial choice to decide these up in any way they want. Signatures. Anywhere there is a space for a witness signature, you must find a witness to sign. Declaration of trust, trust indentor, trust bylaws, and meeting minutes. These headings are pretty self explanatory. The Declaration of Trust is the general guideline or set of rules that is established as the basis for the trust. The trust indentor is a more detailed version of the preceding information. The trust bylaws are the specific rules that govern the trust. They spell out some detailed do's and don'ts of what is allowed. The meeting minutes are the documentation of the day to day activities of the running of the trust. First Secretary, Trust Manager. You may appoint a first secretary. This title is placed here for all those times when you cannot or choose not to be listed as the first trustee. You have a couple of options. One is to be signed on as the first trustee or to take the position as general trust manager. You'll notice that if a trust manager is appointed, they take over day to day activities, whereas a first secretary simply watches over everything and can literally veto anything they don't like. The best position is still the first trustee, as you'll read in this In the trust document, the first trustee cannot be terminated, whereas the other positions can be. Remember this, very important, guys and gals. Meetings. The bylaws briefly mention the various meetings that would be called from time to time. These are required for a trust to be legal. It is here that it is established that all meetings can be held anywhere in the world. This is a great benefit to have. Any restricted version of this clause would need to be addressed in a minute. Privacy. The bylaws grants the beneficiaries immunity from disclosure. Under no circumstances will a trust officer be allowed to disclose the identities of the beneficiaries. Therefore, no non officer shall be permitted to view any documents of this trust organization except for the declaration of trust and the trust indenture sections of the original formation agreement. The meeting minutes grants you the privacy you need to conduct your business affairs the way you see fit. Any additions to the trust assets beyond the initial $100 must be documented with appropriate minutes. Therefore, anything this trust does from here on out will be private and against the wishes of the said law and the board to be disclosed to anyone without just cause or demand. Successor trustee. It is highly advisable to immediately find a successor trustee. Don't delay this appointment very long. It could be crucial to the ongoing, uninterrupted nature of this trust organization. Additional structures, layers of protection. Some astute business persons choose to add layers of protection by setting up additional trust. They'll use a combination of the family and management programs to create an intermingled diversion of entities. Sometimes these additional layers can provide the extra protection to totally render yourself judgment proof. Fraudulent conveyance. The one thing to remember in a scenario of fraudulent conveyance is that the creditors will want to set aside or disallow any transfer of assets which could have been used as collateral for a debt owed them. If you are going to transfer assets out of your possession into a trust for reasons of avoiding present creditors, you will need to show that your transfer was an attempt to settle a debt with a creditor. It's not your fault there's not enough assets to go around to settle up with all the creditors. This means you can place your home into the trust if you owe your mortgage debt. You need to arrange to have another trust to place a lien against your assets with a monetary value that will exceed the value of merchandise being transferred. This will clearly show that your transfer was in an attempt to clear a lien. Just be very careful who operates that other trust and how their names are tied to the present operating trust you are setting up. Those trust officers should be totally different if possible. If you want total protection from this closure of transfer information to any official authorities of any country, you want to set up an offshore trust. No matter what the reason for the transfer, places such as Belize will not allow any documents to be placed into the hands of inappropriate parties, since this document is not recorded in any state, country, or registrar. There is built in protection from improper disclosure. The offshore trust situs can be directed to offshore if you wish. You will need to change the jurisdiction of the trust in an appropriate minute. Multi-layered trust. In creating multiple trust and multi-layered trust, the main objective is to create a diversion of paperwork and close doors for an outsider trying to pry into your affairs. Therefore, you need to understand the simple basics of outlining these structures. The easiest way to understand this is to think of each trust as a real person. When drawing out your examples on paper outlining the flow of funds, etc. Use real persons' names for your example. Trust to clearly understand their relationship with each other. Parent underlying trust. In the example of a parent underlying trust, the scenario is that one trust is either the overall umbrella or a parent, if you will. That is the parent controlling entity over all the other trusts. This works if one trust wants to diversify and yet have some of the same officers running the subordinate trust. In this example, the parent trust could be the settlor of the subordinate trust. You could use the same or some of the same trustees for the subordinate trust. This allows you to name different beneficiaries for different business purposes. An underlying trust is one that is named as beneficiary of several trusts. All the trusts are created for the ultimate benefit of the one trust. This can be used if someone has limited family and wants to diversify. All the diverse business activities will eventually benefit the one beneficiary, who himself operates as a trust entity as well. Brother sister trust. Brother sister trust are ones in which they share managing directors or trustees. They may have different settlors and or different beneficiaries, but essentially these are the diverse business trusts that will eventually funnel down to an underlying entity. They are also the diverse trusts that may have the same settlor, as in the parent trust. These trusts are usually the working trusts that generate most of the revenues for either a parent or underlying entity. Since they may have some of the same directors, trustees, be very careful as to how they relate to each other so that none of the trust officers jeopardizes their fiduciary relationships with their respective beneficiaries. Trust roles: protector, creator, trustee, beneficiary. The creator, grantor, and settlor refer to the same person. The person who has the trust created and who places assets into it. The trustee is the person in whose care and stewardship the trust is placed and who assumes the responsibility for the safety and proper administration of the trust assets. The beneficiary. The beneficiary is the person or entity for whom the assets are being held for distribution at a later time. The protector. The protector is the person appointed by the creator and or the beneficiary to hire and fire trustees. Not every trust has a protector. Whether one is appointed is the sole choice of the creator and or the beneficiary. There are many types of trust, and just like the many types of tools in a toolbox, they each have their own purpose. That's why it's very important in knowing how to operate your trust, how to properly set it up, and what purposes they hold is so important so you can get the most out of your trust. A.W.A.R.E can help you establish your irrevocable or revocable common law trust. A choice between revocable or irrevocable. While revocable trusts are typically established for the benefit of a grantor during their lifetime and pass assets to the named beneficiaries at their passing, irrevocable trust funded during a grantor's lifetime cannot be changed or amended during that time. However, there are lawful ways you can change an irrevocable trust, such as the address and the named trustee, whereas there are other parts that you can't edit. Trust ranges. Types of trust range from a very simple revocable family trust to an irrevocable trust fit to specific family situations, including generation skipping trust, special need trust. Trust can protect assets. Putting assets into an irrevocable trust may allow some people to obtain eligibility for Medicaid benefits as long as they create and fund the trust 5 years before applying for benefits. Irrevocable trust can also help grantors obtain veterans benefits that are asset based. Wealthy may save on taxes. The primary reason the wealthy people put money in trust is so that it can be transferred tax free. But with federal limits reaching record highs, that may not be necessary. Upon death, federal or state estate taxes can be avoided if money in the estate doesn't exceed the current federal $11.4 million or state limits. Those with more can transfer funds into an irrevocable trust to transfer it to others without making it part of a taxable estate. Some states are far below federal limits, such as in New Jersey and Washington, and residents may be more likely to benefit from trust. Not for certain retirement accounts. Retirement accounts cannot be owned by revocable or irrevocable trust. If they were, the retirement account would immediately become taxable. However, non retirement bank accounts, life insurance policies, property, and securities can be owned by a revocable or irrevocable trust. A trust can assist after death. A trust can help avoid probate upon death, ease the process for loved ones, and help them manage money they inherit. Revocable trusts are typically designed to avoid probate, which is the process of settling an estate through the court system. With a trust in place, you are the one who controls that process to meet your financial objectives. If you are concerned your beneficiaries may need help managing the funds, you can pick someone or an entity like a bank to manage the funds for them. You can also limit the beneficiary or direct them on how they're to use the funds through the revocable trust. Confidentiality is more certain. Trusts are not a matter of public record, unlike a will. Okay, ensuring confidentiality, a grantor could put real estate and other personal property in trust that do not reveal ownership in their titles for privacy. For example, a trust could even be used to hold an art collection and the liquid funds required to maintain the collection or to hold a grantor's primary residence for asset protection and privacy. Schedule A. The Schedule A is a list of property held in the trust and is what's used to transfer property into the trust. A.W.A.R.E Secure Party Creditor Package comes with a done for you domestic 14th Amendment Citizen Trust. We don't suggest holding all of your worldly possessions in one place for multiple reasons. I'm going to explain now. Why holding all your assets in one trust is not a wise decision. Holding everything in one location creates risk to the entirety of the property being held as you are mixing low and high liability items. For example, let's say you are driving a trust vehicle and you get into an accident causing liability to the trust. The injured party torts you or possibly sues civilly and winds up with a winning suit against the trust. Everything being held in that trust can be liquidated to satisfy the debt. If you had it in multiple trusts, this would not be an issue as each trust is its own person. Don't place all your fruits in one basket. The Rockefellers have over 700 trusts. Patrick Devine had three different trusts for his estate. I myself have about 6, 7, I believe, right now. A lot of wealthy families create different trusts for various purposes. This is a smart thing to do. Goes to show you not to limit yourself. You can have multiple trusts all working for you and keeping you and your family and their assets private, and you're protected. Many of you will eventually want to exit commerce and destroy the strawman. In destroying the trust, everything must be passed to the beneficiary so that it can be fully extinguished. In this example, anything that is distributed is taxed to the receiver with a Schedule K as well. You lose control to manage the property and finances as the trustee. Therefore, holding the majority of your property via the SPC trust is not the best idea unless you never plan on going fully sovereign. Are you aware that the Rolex watch company is run by a non profitable charity trust? They donate 90% of the profit. The founder was an orphan. The Power of Trust, the Rolex company story. The founder was Hans Wilsdorf, and Rolex was the work of his life. He owned all the shares. He wanted it to survive and thrive after his death, but did not have any children to take over. So he found an ingenious solution. He set up a trust called the Hans Wilsdorf Foundation and gave the shares to the trust. The main objective of the trust is to perpetuate the company, although it does also have a mandate for some minor charity work in Geneva, helping the blind, watchmaking school, etc. It's important to note that the foundation's trustees are not owners or shareholders. They are only custodians, like the board of a nonprofit. They decide how to reinvest the profit, hire or fire the Rolex director, and so on. The power of trust, the Rolex company story. As trustees, they may get a free watch from time to time, but they are not owners and don't benefit financially. So, in a way, Rolex, a globally successful company which generates 4 billion in sales annually, belongs to nobody. Nobody uses this money. How many billions has it hoarded over the years is a mystery, as neither the Rolex companies or the Hans Wilsdorf Foundation's accounts are public. I guess a good part of the profit is reinvested in the company, as there is no shareholder pressure to take profit, and that's why Rolex, my favorite watch, by the way, I own one. I love them. If you ever have an opportunity to buy something you love, something that's gonna hold value, and you can sell it one day, I will go. If you like watches, I will go with Rolex. As you see, they're a great company. Rolex can invest so much into making perfect watches and building the most amazing factories. The staff are well paid too and have lots of holidays. There is a 1% turnover, so they must be pretty happy. Yes, they must be pretty happy. Trust are very powerful, guys as and gals, as you see. The benefits of trust include asset protection, keeping your assets and property private, transfer assets for the benefits of your heirs, beneficiaries, leaving behind meaningful legacies, exist and assist after death. The wealthy can save on taxes, law relief in court cases, avoid probate, open trust bank accounts without your social security number, and more. Assets you can place into the trust are your home, vehicles and automobiles, land, precious metals and jewelry, valuables such as furniture, works of art, antiques, valuable collections such as coin collections, stamps, etc., homes and other types of real estate, types of securities such as bonds, prized possessions, gold and silver, and anything else valuable for the benefit of the heirs and beneficiaries. Guys, invest in gold and silver. Invest in, that's why I say watches are great investments. Like the Rolex is a great company. You can start with a ladies watch, 1,500. They have different types of styles. Men, you can get a Rolex for $2,000, depending on the style. These are assets. These are assets that hold its value. Fiat money, we already know what's going on there. We don't know what's going to happen with the economy, but we do know gold and silver is not going away anytime ever soon. Okay, I don't think it's ever gonna go. It holds its value, unlike the fiat dollar, guys and gals. I hope you enjoyed this webinar and have a better understanding on the importance of trust and how it can benefit you and your family. Now is the time to create a trust or trust if you have not already. You can feel free to ask your questions in the chat section, and one of our team members here will respond in the order which it was received. You can also reach Team Aware by email at info@arewealreallyeducated.com, and be sure to visit our website for more information and discover our services that can help benefit you guys. I love everybody here that's on here. It takes a lot of courage, commitment, dedication, especially on a Sunday night. I hope I did my very best to speed up this webinar, because I know a lot of people have to go back tomorrow to work, and I hope you no longer soon will continue to have to work for someone else and follow your passions, your goals and dreams in life, because we all have goals and dreams. We all want to be prosperous and abundant and healthy. We have it at our disposal. We just have to wake up, because they have people in a daze, with the fluoride in the world, in the water, the chemtrails in the air, the depletion of the soil, you know, the medications, the herbicides, the pesticides. I get it. People are being bombarded. This is why it's very important to take care of your temples. Feed your body, your temple, the best of the best. Go organic as much as possible, guys. Reconsider how you're eating, how you're living your lifestyle, getting your mind right, because it's very important that you continue to learn and educate yourself. And as you continue to learn and educate yourself, you start taking care of yourself more and more. They don't want to see people prospering and growing, because there's no money in health and wellness for them. Okay, there's no money in keeping people ignorant. They want people to continue to be ignorant because they benefit. But you have to finally say enough is enough. It took all of you guys, more than a dozen people here on this webinar, to get on this call, this webinar tonight, to listen to the information about trust. But I leave you with these final words. Okay, my life changed when I changed my lifestyle. My life changed when I changed the way I eat. I was eating. My life changed when I changed my mindset. When I went from negative to positive, positive to negative, depending on the etymology. You see, I shifted things about myself that no longer served me. And if you continue to grow by learning, and you continue to see that by you learning, your life is improving, by you teaching yourself, by you giving your body, your temple, the best of the best, okay? More people care about the oil in their car than they do about the food they put in their mouths. Let's wake up. Let's become awoken. Let's become more aware, because knowledge is power, but knowledge is power only if you use it. Peace and blessings. I'm Emilio. Stay aware.
Freunde, nicht diese Töne, sondern lasst uns angenehmere anstimmen. Und Freude, schöner Götter, Funkentochter aus Elysium, wir betreten feuertrunken himmlische dein Heiligtum. Deine Zauber binden wieder, was die Moore streng geteilt. Alle Menschen werden Brüder, wo dein sanfter Flügel weilt. Deine Zauber binden wieder, was die Moore streng geteilt. Alle Menschen werden Brüder, wo dein sanfter Flügel weilt. Wie der große Wunsch gelungen, eines Freundes Freund zu sein, der ein holdes Weib errungen, mische seinen Jubel ein. Der nur eine Seele seinen auf den Erdengrund, und wir stiegen von der Stille, weinen sich aus diesem Grund. Freude trinken alle Wiesen an den Brüsten der Natur. Alle Guten, alle Bösen folgen ihrer Rosenspur. Kenntnisse gab sie uns und Reden, einen Freund geprüft in Tod. Bonus hat den Tod gegeben und der Herr steht vor Gott.